Hello and welcome to the CPD Group podcast. Join us as we guide you through all things CPD, interview some special guests and offer advice to help your business thrive. We hope you enjoy listening. Welcome back to the CPD Group podcast, where we're talking to Wayne Bynon about all legal ramifications around our accreditation services. So this is part 3 of a 3-part series. So if you've missed part 1 and part 2, go back and have a look and see what Wayne's got to share with us. Okay, so we cover in part 1 all about our provider accreditation. Part 2 is about our trainer accreditation. And today we're going to be talking about part 3, our activities. Okay, so what constitutes an activity in our world? So we are talking about training courses and training materials. So when you're looking to have your training materials accredited with us, we advise you to get familiar with our accredited framework. So you can find it on our website, and it goes from A to D, talking about all the various elements that our assessors are going to be measuring your training materials against. Now, Wayne here, who's been sitting with us over the last couple of episodes of the series, is a specialist in intellectual property. So I've been trying to squeeze lots of different information out of him in different areas that aren't really his specialism, but he's been giving us some great advice. But on this area, this is what Wayne knows the best, okay? So please take heed of what Wayne's got to share with you today about protecting your materials and making sure your intellectual property is protected at all times and what you can do in that area, okay? So you'll find that I, within our accredited framework, is specifically about intellectual property. It's a very, very important area. So Wayne, let's get stuck into this, shall we?
Sure
Okay?
thing. Yep.
So intellectual property, what is it?
Okay, Andy. What is intellectual property? I could spend 2
quite
days.
broad.
I could spend 2 days answering that question, but it is the expression of original thought. That's essentially what it is, and it falls in broadly into 4 categories. So you've got copyright, which covers written content, musical works, artistic works, and sound recordings. Secondly, you have trademarks, which cover names, logos, brand identifiers, such as Nike or McDonald's. Then you have patents, which cover broadly inventions. So that can be physical inventions like a mousetrap, or drugs in the pharmaceutical space also qualify for patent protection. And then lastly, we talk about design rights, which are a form of copyright, or an extension of the copyright body, but they cover design features of physical products. So, for example, the functional design of the shape of a handle on a spade, for example, that kind of thing. Or one of the recent cases to have gone through the courts related to the children's luggage called the trunkie, and whether an infringing party had got too close to that, the design features of the trunkie suitcase. So design covers both registered design and unregistered design, both in the UK and across Europe. So those are the 4 main areas of intellectual property, and like I say, the key thing to remember here is that intellectual property is intended to cover the expression of original thought. So it needs to be manifested in some way, whether that's in writings, like say sound recording, the logo committed to paper, or the invention put down and recorded as a form of a registered patent. What intellectual property law doesn't cover is thoughts in your own head when you keep them to yourself. They're there, great, but you'll only afford yourself protection once they're committed. So, like I've just touched upon, some areas of intellectual property operate under a registered system, some don't. And probably most relevant to this conversation is copyright and the content that your trainers are creating when they're delivering their courses. And copyright in the UK operates under an unregistered system, which means that there's no requirement to go and register copyright with any body, such as the Intellectual Property Office or anything like that. You're afforded that protection as soon as you put pen to paper and share those that material. The same goes for sound recordings, video content. As soon as it's created, you're afforded that protection, and effectively you're given the exclusive rights over the use and exploitation of those creative works. So hopefully that gives you a flavour of what we're talking about here.
Absolutely. It sounds like it's quite a big world, intellectual property.
It is, and that's one of the best things about practicing in this area as a lawyer, because every case I come across is distinctly different from the previous one. I could be dealing with a patent infringement case relating to the development of a cancer drug one week, and then the next week talking about brand protection for a greetings card manufacturer or something like that. So very, very wide spectrum of work, very, very interesting, quite often at the cutting edge of various technologies. So as a lawyer, I get to learn an awful lot about different inventions, different creations, different content. So very interesting. Yeah,
I'm sure. It sounds interesting, to be honest. Yeah. So, when we're talking about the creation, and generally what we find is it's video, or it's the written word that we're presented with as part of our application process. Okay, so, what can companies do to help protect their IP in the general sense?
Okay, so we're talking about copyright again.
Right.
Okay, this is written materials that they're creating. Again, as I said a moment ago, there's no official register on which you can go and register your copyright. There are unofficial registers out there, which might take a fee. Key piece of advice, don't bother with those, certainly not in the UK. I should say in the US, they do operate under a registered system, so the law is slightly different over there. But when we're talking about UK companies, which we are predominantly talking about here, there's no need to go off and register any kind of intellectual property protection over the content that you create. Now, lots of the listeners to this podcast will be familiar with the copyright logo.
Yeah.
And at the bottom of websites or printed materials, we often see copyright protected and then a year. That doesn't afford the copyright owner of those works any more protection. It's simply a warning sign to others that this content is copyright protected, as soon as it was created, as I said a moment ago, and warns others off from potentially copying it without the owner's permission. So that's one step that people, copyright creators can adopt. But I think that one of the most important things to ensure here is that when content is being created by your training providers, it is either original content that they've created, or if they are using other people's content, taking content off the internet, for example, that content is either open source content, where you don't need a license to use it, or they've acquired the appropriate permission of the copyright owner to use that and exploit that copyright content. Without that permission or authorization from the copyright owner, your trainers potentially face the risk of copyright infringement action, which broadly speaking amounts to an allegation that you've copied their works without their permission and you've derived some kind of financial benefit from doing that. And so the copyright owner may be entitled to seek an injunction, so a prohibitive injunction preventing your trainers from using their content again. And secondly, and possibly more importantly, either a damages claim or an account of profits. So forcing your trainers to account to them for the profits that they've generated from using that copyright protected material without their permission. Now, I've rattled through an awful lot there, and there are some nuances and what have you I could go into, but it's important to stress that when when they're using content, they either created it themselves or they've got the owner's permission to use it.
Excellent. Now, when you talk about creating it yourself, how far does this go? Because we've seen multiple things, as you can imagine, right? We've seen training manuals sent to us where every piece of it has been, you simply Google a sentence from it and you'll find the original works online somewhere, okay? And the whole manual is made up of various different articles from different authors all over the world, so technically the content is fantastic. The learning journey is really good. That's because it's been essentially written by the best doctors or the best people in the world, you know, this kind of thing. But can I just tweak the words a little bit, change a little bit here, there, and everywhere, and it still becomes my own?
Okay, so we're getting into the weeds here of copyright infringement. But I'll try and explain this as simply as possible. But the courts tend to adopt a qualitative rather than a quantitative approach.
Right.
So what I mean by that is if you take a page of written material and you divide it up into 5 paragraphs, if a training provider takes a paragraph from 5 different sources and pops it into one document, that training provider will have infringed the copyright belonging to all 5 of those original authors. If they take a piece of A4 paper, written prose, and you change all of the sentences slightly so that it reads slightly different, or there's a creative element or input into creating something new throughout the document, then you're less likely to infringe. Okay, now if you only change 1 or 2 words and the overall structure of the sentences and the messaging remains the same, then you're pushing towards infringement. It's a sliding scale and it's quite subjective. And we talked just off air before we started this podcast about the subjective nature of lots of these intellectual property type infringement claims, where quite often it's down to the assessment of the judge as to whether or the extent to which something has or has not been copied.
It sounds like a bit of a minefield, doesn't it? So ultimately, the main advice is make it original to start with. Is that fair to say?
It goes back to my very first point. Intellectual property protects the expression of original thought. So if it's your own work, then you're fine. I should say that you could have 2 training providers delivering the same kind of course on the same subject matter, sit in 2 separate rooms and create identical training materials because of their experiences, their training, where they went to school, all the rest of it. They just happen by pure coincidence to create something identical. They will both be entitled to copyright protection over their own materials. It's the copying that's prohibited.
Right.
Okay. So it can happen in the artistic or musical worlds, so long as the content of the creation is an expression of your own original thought rather than having been copied from elsewhere. Then you're okay.
So in terms of licensing as well around this, so again, when our manuals come to us, from our training providers who submit them for accreditation, there's written content, obviously, but it's generally supported by imagery. Now, we've seen on many occasions, which we've had to send back, people using images with Shutterstock watermark right across the middle, which implies to us that there's no license behind that. Now, do people need to have these licenses in place? And if so, what are the implications if they're using these images without that license?
Okay, so I touched a moment ago about obtaining the copyright owner's consent authorization to use their works. And that's effectively what we're talking about when we talk about licensing, copyright licensing. The most important thing to ensure here is that that license, if it's been obtained, is in writing, and that it provides your trainers with the right kind of license. So the ability to use it for training purposes. So licenses are often bespoke and give the licensee rights to use works in specific instances or for a specified period of time. So because a training provider has a license in place, it doesn't necessarily mean that they've got carte blanche to use that material in any way they want for whatever period they want. So it's important to look at the terms of the license. But fundamentally, the point you're touching on is without the copyright owner's permission, use of that content constitutes copyright infringement. So it is vital that that permission is obtained in the form of a written license.
So you mentioned as well in terms of licensing about open licenses or open source licenses. I'm not sure which way you phrased that. I mean, what does that mean?
So there are certain instances where copyright creators are happy for the world to use their content, and they put it up online, and then be some specific wording around that content which says that anybody is free to come and use it. So they're effectively giving a license to the world to use their content. And there are specific websites that you can go to which has content on there, and photographs and things like that, where you're free to use them without paying any kind of license fee or obtaining any additional authorization.
Right, that sounds very similar to, a course came into us, after the COVID period, that kind of thing, and they were using NHS imagery and, statements from the NHS websites and things like that. So when our assessment team looked into it, there was actually an open license, but what they requested is that you referenced it in a very specific way, and this individual who'd sent us the application hadn't referenced in that way. Does that mean that piece is then, infringing upon copyright because they've not done what they've been requested to do?
Yeah, in all likelihood, yes, and it comes back to this point about the scope and the terms of the license. So what we're talking about there is not strictly open source in the bare sense that we were talking about a moment ago. That permission for others to use that content was conditional, and without those conditions being met, as you say, use of it would have amounted to copyright infringement.
Yeah, that's really useful to know, because we do see lots of people using that kind of open source. The way you've described it, it sounds very much like the information that people are using, but making sure they protect themselves on those conditions is highly important. Now, I've heard as well in terms of protecting your own IP, and now please tell me if this is a myth or not, that if I write something original, I put it in an envelope and post it to myself, and then that is evidence that I've actually written it and that it's original and that I've got a date stamp on it and everything, and I leave it closed in a safe, and then if anything ever comes of it, I can whip that out and say, look at the date on that. Is that a real thing?
That has happened, and that is a real thing. It's not a misconception. What we're talking about here is evidencing authorship.
Yeah.
So in any copyright infringement claim, the first thing you need to do is prove ownership. Prove that you are the owner of those works and you've not assigned them to anybody else. And quite often, before the IT revolution, when things were created in hand and there was no electronic record of when things were created, quite a simple way of proving it was to obtain a stamp from the post office, and you can date and evidence when things were created. It was evidence. It never constituted irrefutable categoric evidence, but it was helpful to establish A, who the author was, and B, when it was when the content was created. But of course, these days, with the advent of technology, most things are created using some kind of computer or electronic device, and so most things are date stamped down to each time it's edited or amended. So the need to create that additional evidence bank by posting things to yourself and what have you have tended to drift away, and it's not really used these days.
Right, super. So if I was, let's say, creating a training manual, okay, and I asked you to give me a piece of information around intellectual property, and I pop that in. And then I go off and I sell this manual, and use it through my training and everything like that. Do you have any claim on that written piece and ask me for any money out of the back of that? Or is that mine, or do I need to have you under contract, or what's the best way to do that?
So just to speak that back to you so I properly understand the question. If I've created some content, you take it without my permission and you incorporate it into your training manual.
Yeah, I ask you to write me something. Yeah, but I'm not giving you the full information about where I'm going to use it.
Okay, so again, it's important. So what you're effectively asking me to do is create something and license it to you so you can use it. So going back to my earlier point, if you're obtaining a license from somebody else to use content, it's important that the terms of that license are recorded in writing. And again, cheeky plug for the legal profession, the best way to do that is to instruct a lawyer to create a formal license.
So I know this is a really broad question. So if you were to give one solid piece of advice to people out there who are writing their own educational content for their training materials, what advice would that be other than originality?
I think if you're running a business where there are one or two individuals creating the content and you have effective oversight of all the content being created, that's a fairly straightforward situation. I think the problems come when your organizations grow and you have teams of people creating content. And it's this, and that's where companies can run into trouble, where parts of the business perhaps aren't properly educated around this stuff, around the intellectual property, and ensuring that they're not infringing, they're not taking content from the web without copyright owners' protection. So I think my main tip in a very convoluted way would be to ensure as your business grows that training, proper training, frequent training is rolled out to everybody that's creating content, so that you don't run into any of the problems that we've talked around infringement and the possible ramifications if you are using content without owner's permission.
So, as a training provider, as you've mentioned in that kind of in your answer there, I've got a team of people working for me who are creating the content on my behalf. I've got them under contract so that everybody knows where they stand. But then they have used content from the internet, and I wasn't aware of it. So I think this is original content, and I'm selling it on that basis. What happens if the original author then came to me and said, You've stolen my material here without my consent? Where would I stand as a training provider when it was one of my staff members that did that?
Yeah, so as employer, we're talking about vicarious liability here. So
Right.
if the employee committed that infringing act during the course of their employment, most likely it would be the company that would be pursued for copyright infringement. So that's why I'm talking about the importance of training and regular updates and what have you as your business grows and develops. And the same goes for when you're outsourcing the creation of content. So it might not be your employees, but you might instruct the services of an external copywriter, for example, to create content for you. It's important that when you're engaging with these individuals, you obtain, well, first of all, that there's a proper document setting out the terms on which you're engaging that third-party content creator, but it also provides you with some kind of assurance or indemnity in terms of the originality of the content that they're creating for you, so that in the event that your external copyright provider does infringe somebody else's copyright infringement, you've got some kind of recourse against that company or that individual if they've given you contractual assurances around the originality of that content. Excellent
advice. So imagine, I'm just putting you on the spot here, Wayne. Imagine I've created a new original training manual, using it to train lots and lots of different learners out there. One of those learners then takes that manual, puts their own brand on it, and starts using it as their own. How do I protect myself in that instance, and what can I do about that?
Okay, so protection, as I've already talked about, there is no formal register in which you can protect your copyright. So one of the ways of warning others off from copying or infringing your copyright is to put the copyright logo that we know so well at the bottom of all the, possibly on every page of the manual if necessary, but certainly on the front and on the inside cover. And then if infringement does happen, then the first thing to do is speak to an intellectual property lawyer about potential action against that company or individual that's used your content without your permission. But ultimately, the two things that the law entitles you to do is to seek an injunction to prevent them from continuing to use your material, and damages or an account of profits. Account of profits is probably more preferable if the party that's infringing has generated significant income from using your content.
Another case that came up, actually, which I'm aware of, it wasn't through the CPD group, actually, but I'm aware of it through other jobs that I was used to be in. Content was written, let's just say 1990, okay? Little copyright sign, copyright 1990, written on the front cover. Somebody then stole those materials and then put copyright 1989 on the front of theirs. So theirs looked like it was done before the 1990 original version. How would a court pull that, or a lawyer like yourself, pull that apart?
Okay, so it goes back to the point that you raised a moment ago around date stamping or sending things in the post yourself. It's the ability to evidence who created it and when.
Yeah.
And there, in that instance, there would inevitably be an evidential battle between the true owner that created it in 1990 and the infringing party who alleged they created it 1 year earlier. And whatever evidence they could present to the court to convince the court that the one or other party were correct would probably win the day.
Right. Okay. So it's kind of a bit murky, that.
It is, but it probably highlights the importance of keeping an evidential trail
Absolutely.
of when various content is created. Like I said earlier, these days it is a lot easier because you have IT systems that can be pulled apart and interrogated, and you can prove when written prose was created on your laptop or whatever electronic device you're using.
I know we've covered loads, and thank you very much for this information. It's really useful, especially to the viewers and listeners, of course. But have you got any final hints and tips that you would give in relation to IP, just in general?
If in doubt, speak to a qualified intellectual property specialist. Today on this podcast, I've run through some broad principles around specific copyright infringement or authorizations to use copyright materials. But IP is a specific area of law, and there are lots of exceptions and nuances to it that layer on top of the basics that I've set out today. So it's often dangerous to assess a situation or proceed. If you're unsure, always go and speak to a lawyer, because they'll be able to give you that certainty and ensure that you move forward with your business on a sure footing and you're protected against potential adverse legal action, which can drain on resources, both time and financial, for any business. And quite often the advice will be quite straightforward, and the steps that you can take to protect yourself can be fairly minimal. The dangers arise when you potentially head on the wrong path or use infringing content for a period of time, generate significant profits as a result of that use, and then face significant legal action. So, in a very convoluted way, my key bit of advice was to seek advice early.
Well, there you have it, viewers and listeners. From the man himself, this is Wayne Bynon from HCR Law. If you're going to listen to anyone, I would recommend listening to Wayne, because he knows his stuff in this area, okay? So look for legal advice if you're looking to protect your intellectual property. And thank you very much for joining us on this 3-part series looking at the law behind our accreditation services. Thank you very much, everyone, and join us in the next podcast. Bye-bye. Thank you for tuning in to the CPD Group podcast. Be sure to tune in next time for more helpful content. See you soon.
Before you go, did you know that you could receive a free CPD certificate from listening to this podcast? All you need to do is head over to the cpd.group/podcast. That's the cpd.group/podcast and enter the confirmation code 800015.